Today we are going to discuss the very basic things of constitution of the topic of Indian polity. So the first question is, what is constitution? So in the context of states, the constitution is the set of fundamental rules, principles, which are necessary for running and regulating the state. So in terms of Indian constitution, it is the lengthiest constitution ever in the world, and Indian constitution is not solely made by the Indian elements, rather it is culmination of number of other constitutions. The basic principles are taken from the other countries' constitution, but the things are not taken as it is. They are modified in Indian terms according to the nerves of the Indian peoples. So we cannot say that whole of the constitution is taken from other countries and there is no any element indigenously. So the basic principles have been taken, and the core is involved according to the Indian mood and Indian rules. So constitution have total 22 parts, and originally it was 395 article. Now it is, after amendment, the number of articles have been increased. The important part, and I would say it is importantly part of discussion, the preamble. So preamble is the introductory part of the constitution. On preamble, Supreme Court have affirmed that it signifies the mood of the framers of constitution. So in subsequent cases, like in Keshwanand Bharati cases, it is affirmed by Supreme Court that it is basic structure of the constitution. And now again the question comes, whether every constitution have preamble. So no, every constitution don't have preamble, but in the Indian context we do have preamble. And another question is, can preamble be amended? Yes, preamble has been amended at once. The socialist and secular word have been added. In original constitution and original preamble, socialist and secular was not there, but after the amendment it was added. So the preamble is the introductory part, and it is known as the basic structure of the constitution and moods of the framers of the constitution, and the rulings of Supreme Court are done in the way to constitute preamble. Rather, preamble is not enforceable. One cannot get the whole decision on the basis of preamble. But the preamble is integral part of constitution, and whatever the decision can be made by the Supreme Court, the rulings can be done by the Supreme Court is in manner not to violate preamble. The other thing is, what is schedule? So schedule is the, I would say, part of constitution, but it is the additional thing. The next question is whether the articles are came under the schedule, or the schedules are talked in articles. So yes, the schedules are discussed in terms of articles, and there are total 12 schedules from 1 to 12, and originally it was 8. Later, due to the subsequent amendments, 4 schedules were added. And the next part is the articles. So article is the full detailing of the constitution. Whatever the provisions have been defined by the constitution are described in a detailed manner with respect to articles. And I have said there are 395 articles originally, but later subsequent amendments have increased the number of articles. And the articles are categorized in parts, that is total 22 parts. For example, the first part is the union and the states, where total 4 articles are there. And in second part, the citizenship, where the articles 5 to 11 is discussed there. And in the third part, very important, that is fundamental rights, from article 12 to 35 there. And the fourth part is DPSP, Directive Principles of State Policy. Now the one question is very important. The citizen can claim on the DPSP or the fundamental rights. So fundamental rights are the right on which the citizens of India can claim to the states, while DPSPs are the rulings, not rulings, they are the methodologies described in the constitution to run the state in a good governance manner. So one cannot go for full-fledged claim on DPSP, and these are the things which tells the states to inculcate the principles involved in the DPSP, that is from article number 36 to article 51. In fundamental rights, article 21 is one of the most important article, which is right to equality and personal liberty, right to life, Article 21 discussed all these things. So it is one of the most important articles, and it is one of the important articles which cannot be suspended even during emergency provision. But this is not sacrosanct. Some of the provision can be denied by the state in the name of national interest. And in the same manner, Article 19 is also one of the important article which safeguards the voice of the citizen. And there are some articles which are provided to all the citizens, while there are some other articles which are, I would say, the fundamental rights which are only provided to the Indian people, like Article 15, 16, 19, 29 and 30. These are the exclusive articles which are only provided to the citizens of India, and it's not enforceable in regarding to the foreigners. Means the foreign people cannot claim the article over there, while the articles like Article 21, Article 18, 17, 16, not 16, Articles 17, 18, 21 are available to all these people, whether they are citizen of India or they are foreigners. Now the important part is fundamental duties. They are categorized in Part 4A. This was also added by the amendment. It was not in the Indian Constitution originally. So fundamental duty was involved in the Indian Constitution with the motivation from socialist principles of USSR. So fundamental duties are the things what the state expect from the citizen. It is converse of the fundamental rights, where in fundamental rights the citizen claims their right to the state, and here in fundamental duties the states expect all these duties to fulfilled by the citizens of India. And yes, they are not rigorous, and state cannot enforce to somebody to follow, but they are the duties of every citizen to follow these duties which are in Part 4A, that is in Article 51A.